Hey.
We welcome now law professor Christopher Green. Hey, Professor, good to see you again, sir.
Good to see you.
So the Supreme Court's been pretty busy the last couple of weeks, handing down rulings, decisions. One just this morning, right, concerning the, I believe it was a suit contesting that the Biden administration essentially instructed or even colluded with social media platforms in what they allowed to be published. So I believe the court said you don't have standing here. It was the ultimate decision.
Right.
So they turned the case down.
Yeah. So they've had two of the ones recently that looked like they might have been really big. So the FDA had a dispute with a group of physicians, Physicians for Hippocratic Medicine, that wanted to restrict abortifacients, abortion pills, and then now this morning this dispute with it's a three-way dispute about individual users, Facebook, and mostly Facebook, but also a little bit of Twitter and YouTube, and then the federal government. So what they did this morning, essentially, they said individual users they might be able to litigate disputes with Facebook. There's another big case about that. So Texas and Florida have told Facebook and social media folks they're not allowed to discriminate. That case they still haven't released. But essentially they said, well, you got your users and the Facebook, and then the Facebook and the feds, and because Facebook wasn't the one complaining about this pressure from the feds, individual users weren't allowed to complain about somebody else being, kind of sort of censored. There was a case, we talked a little bit about this case from New York that came out a couple weeks ago. It was argued the same time as the case from today, and that was about a bunch of pressure on insurers to drop the NRA. A number of people were a little surprised. Oh, why did they release the New York one but not tell us about the feds pressuring Facebook? Well, this explains it, because it was going to go off on this standing question. So those two are big ones for my course for the fall, when I explain all this complicated procedural stuff for my students, but much less hot button than the gun one and the tax one. Those are the two other big ones that have come out recently.
Yeah, the tax one intrigued me quite a bit. It deals to some extent with the 16th Amendment. So you want to explain that to the folks? This was, I believe the plaintiffs were Moore, correct? A couple.
That's right.
That
so
had an investment in an Indian company, I believe. And so this just deals with whether or not they're subject to federal income taxes on profits made by this company in which they invested.
Yes, profits made by this overseas company that were not yet distributed back
right.
to an American company. So in international tax, this has been an issue for a long time. But they basically what Congress did is they passed this one-time mandatory repatriation tax that would treat income overseas as if it was earned in America. And of course, the 16th Amendment, it says you can tax income. So not ownership of something as such, but actually getting income. So essentially what the statute did was treat owning a piece of a foreign corporation as if you had gotten the income. So there was a bunch of questions about when Congress is allowed to treat ownership of something as if you've got income. So the Biden administration, they went big and they said, we should be able to treat this anytime at all. We can have a complete mark-to-market where every year you'd have to pay on appreciation in all the stock you own. And the court very pointedly did not embrace that theory. And I think a number of the ways they expressed themselves made it very clear that a general wealth tax would not be constitutional. They talked about all personal property, or they didn't talk about personal property. No, they talked about property taxes being different from an income tax, and the fact that they did not distinguish personal property from real property, so land and stuff like that, really suggests that that's the anti-wealth tax interpretation of really it's the word direct from the original Constitution. So Foes of broad federal taxing power, I think, were at least somewhat encouraged by the way in which they upheld it. There were two dissents that wanted to strike down the mandatory repatriation, and then two of the justices said this may have been unconstitutional, but it just wasn't sufficiently proved by the Moores. And then the gun one. Do we have how much time do we have before the break?
Yeah, we got 6-7 minutes. Go ahead.
Yeah. So Rahimi was, I think, the sort of the poster child for gun regulation.
Okay.
He had behaved violently with a couple of girlfriends. So you got this statute 922G, and it has maybe 10, 11 different categories of disarmament. And one of them, so some of them have to do with actually being convicted of a crime, but this was a provision about being subject to a domestic violence restraining order. Now, so it's a Second Amendment challenge to the federal policy of saying if you have a state and local restraining order against you, you can't have a gun. So the restraining orders themselves didn't tell him he couldn't have a gun. So that would be a question of what Texas could do with respect to this fellow. But the federal government came in and said, we want to be able to disarm folks like that because they're dangerous. So the big dispute was just how analogous this kind of disarmament provision was to a couple of examples that have existed for a long time. Bans on going around armed and intimidating people, and suretyship rules about having to put up bond if you act improperly, including in domestic violence situations. So they split 8-1, basically about how close that analogy was in the particular case. And Justice Thomas, who wrote this case from 2 years ago, the Bruin case, he thought the analogy wasn't tight enough, but the other justices thought it was. All three of the Trump justices wrote solo concurrences, kind of setting out what they think about constitutional theory. So really, ever since Rahimi came out, everyone on Twitter, or at least the constitutional theory part of Twitter, has been quite energetically going full steam. Of course, we're waiting for these. We got another 6-7 big cases coming out tomorrow and Friday, probably. But probably, I think, likely to have 5 cases Thursday and 5 cases on Friday. So we're all, of course, what we spend our summers doing is writing stuff about what the Supreme Court has given us. So we're, trying to figure out, Gorsuch and Kavanaugh and Barrett, the extent to which they really differ. It's a little hard to tell, but Kavanaugh thinks it's important to know that later tradition can be important. Barrett was emphasizing, again, she did this last week as well, that we have to explain why exactly it's relevant. And Gorsuch was ringing the bell about just we have to stay in our lane. It's not clear really that, I think you can have all three of those together without too much trouble. They weren't directly responding to each other. Other people have looked at them as if they're kind of having some big food fight. I think that kind of stuff is overwrought. There's no great rejection of Justice Thomas's approach, no rejection of Bruin or anything like that. So I think the need for people writing, overheated press accounts about, the great villains have won or lost or something, is causing them to see, you kind of overestimate the importance of those. But some of these other ones, they're going to be big. A couple of big administrative law ones coming about administrative adjudication and a deference to administrative interpretations of statutes. Those are two big ones. Trump immunity, and then these net choice cases about Florida and Texas telling Facebook and Twitter and YouTube not to discriminate against people of one creed. So that's exciting couple days to come, but a slightly less exciting Wednesday than Nebu thought.
Yeah, the Trump immunity case, I guess I felt like we may have a decision at this point. Do you think, what's the deadline for that? Might we have that before the conventions, for example, the convention at the RNC, middle of July?
Yeah, so I would be very surprised if they even go to next Monday. Okay. 5 a day is something they can do. They're busy for July. So One question
Wow.
is how many are going to get decided before the debate on Thursday night?
Yeah,
and how many
okay.
will
Well,
be the
I
next
mean,
morning.
that would be huge if we'd get the immunity decision prior to tomorrow night's debate. I don't know if that's probable,
Well, we had a
but
debate
that would be.
the day Justice Scalia died, there was a presidential debate, and it was
That's
really that was one of the first times that Trump really said, "Oh, we've got a bunch of great candidates," and kind of rattled off some names, and people like me were like, "Oh, wow, he knows the names of some pretty good appellate judges." This is
Always good talking to you, Professor. Really appreciate your insight. I know we got more decisions coming. I'm sure we'll have you back on to discuss those. Thanks a lot, sir. Appreciate it.
good to see you. Take care.
We're coming right back, folks, in the Element Well